Hi there. Thanks for joining today. My name is Shab, or Shabna Makrami. I'll be doing the, a consultation, a live streaming consultation today. We have a few questions. We got many, but I've kind of summarized them, and I'll be hopefully answering and putting it into 5 main categories. So the first concern, or many concerns related to this, was about processing times and why everything is delayed, how long will it take, or what additional time should you expect, and anything related to processing times. So in regards to processing times, if you go on CIC's website, you can see that for spousal sponsorship, doesn't matter which country you're coming from, they're advertising that it takes about 12 months. But to be honest, 12 months for most countries is not realistic. It actually takes longer. So if you are sponsoring someone from India or Pakistan, you could expect a far more lengthier processing time. And it looks really nice when you see 12 months, but unfortunately clients do get frustrated when it's taken 18 months or 22 months, and they think that there's something wrong with their application. Meanwhile, in practice, that is the normal processing time. Now, for some other countries, like European countries, from the US, 12 months is average. It's reasonable to expect an application within that time. So that's very good. Now, sometimes it's not about the processing time of immigration responding to your inquiry or your application. There's actually something substantially wrong with your file, hence the delay. And so unless I don't take over the file and unless I don't review all the forms that you submitted, all the documents you submitted, it's hard for me to know, is the processing time reasonable or is it unreasonable? And reasonable is, again, you've submitted everything, the file is up to date, you have strong documentation, you have strong arguments, and now you're in queue, and then the officer will get back to you. So that's reasonable. Unreasonable could be that you've done all of that, and despite that, you're still waiting, and there's zero communication. Then you can ask the immigration officer as a follow-up, as a courtesy, to say, hey, we submitted on this time, we're kind of waiting for the next step. And you can do that with a case-specific inquiry. You can send a letter to Ottawa, you can send a letter to the consulate, depending on where you submitted it, depending on how long it's been taken, we then decide which avenue is reasonable. Try not to follow up every month with the consulate. This could severely affect your application and could irritate the officer. If you've received the UCI number, if you've received the file number, and you have done a follow-up, you should wait a couple of months, at least 3 months, before you follow up again. And remember, just because it says 12 months doesn't mean it's going to be 12 months. And it's still reasonable after 12 months. Now, what happens a lot of times is that clients always think that they've submitted a strong application, and then they say it's been 12 months or it's been longer than 12 months. Again, we're focusing on the spousal application here. And then they get something called a procedural fairness letter. And that is basically where the officer says, okay, I have this major concern and you have X amount of days to respond to it to hopefully alleviate my concern. And so that's when clients freak out and they contact us and say, oh my God, I didn't know this was a problem. How do I fix it? Keep in mind, even though you're getting a procedural fairness letter, you've already set the tone for the officer. You've already convinced the officer to a large degree that your application should have a negative decision because there's a lack of documentation. A lot of these officers are very good, and in my 13 years of experience, they barely make mistakes. So if you get a procedural fairness letter, it's because most likely you really did not hit that point. And so the officer is giving you an opportunity to explain that. So keep in mind, processing times, 12 months is reasonable for spousal, 18 months is reasonable for a spousal application from India and Pakistan, Manila. These are lengthy processing times. And within a reasonable time, you can do a follow-up, have a courtesy follow-up with the officer, so long as you have the UCI number, and have a second pair of eyes review your file. If you're concerned about the processing time, it's likely that there's something missing, hence the delay in a response, okay? So that was one of the major questions we kept getting about processing times. Now, visitor visas and study permits and super visas, they all have their own processing times, which you can again look at on CIC's website, but with a grain of salt, because just because it says it's 1 month processing doesn't mean you're going to get a decision within 1 month, or just because it says 4 months doesn't mean you're going to get a decision within 4 months. And so you really have to understand what is happening in real life, okay? And only someone who does it as a living on a day-to-day can really give you a realistic expectation. A lot of representatives will tell you what you want to hear, and they'll say, oh yes, your application should take only 1 month to get approved, and it's going to be fine. And you hire that person, and then later on you get frustrated because that's not the processing time. So anyone that tells you they have control over processing time is not being honest with you. Processing time is not in anyone's control. How you control it is by making sure that you have a thorough application submitted. Okay, second question is very specific, so I'll just read it out and then we can address it. This individual is saying that my son got a reckless driving charge, and he was 19 at the time, and then he successfully completed the requirements of his charge. He's now 24, or will be 24, sorry, in August, and it has been 5 years since the arrest. Will he be denied entry in Canada? And that's a very good question. So if you have an inadmissibility issue, and specifically in this case, it's a criminal inadmissibility, reckless driving in Canada is considered a highway traffic offense, not a criminal offense, but we have to see if certain reckless drivings in the United States can be a criminal offense in Canada. So it's the equivalency. Is it a dangerous driving? Is it an actual reckless driving? Or, so most of the times a reckless driving in the United States is considered a dangerous driving in Canada, and so that's not a criminal offense. But if it's a equivalency of a criminal offense, and we have to know what the sentence is, how did he get this offense, how did he get his charge, what did he have to serve, how long was the probation, did he have a fine. Assuming it is a criminal offense, assuming it's equated to the Canadian Criminal Code, what I'm assuming that this applicant is saying is that since it's been 5 years and he's deemed rehabilitated, will he still have an issue? And the answer is yes. It's not 5 years since the arrest, it's 5 years from the date of completing the sentence. And that sentence could be everything that the court issued, from fines to probation to house arrest or whatever the conditions were. After 5 years of completing that sentence, you could be considered deemed rehabilitated. Nonetheless, the officers will still ask questions, and they have to equate it to the Canadian Criminal Code. So it's not a simple yes or no question, because US has what they call a felony offense and then a misdemeanor. Canada has 3 levels. We have summary, hybrid, and indictable. So a hybrid means it can be summary, it can be an indictable offense. Most offenses are that, hybrid. And depending on the sentence given, then we determine if it was a summary or if it was an indictable offense. So assuming your son has a summary offense, if the offense happened in Canada, then I would recommend what we call a port of entry package, explaining all of that and making the legal arguments and giving that to the officer. Or if you really want to be safe, you could do an application information only to the consulate and get a formal letter from them to state that your son is not inadmissible to Canada, and so therefore he should be allowed as an American citizen. There's obviously other screenings that need to be done to make sure that you're a bona fide visitor to Canada. Why are you coming? How long are you planning to stay, etc. If your son is deemed inadmissible to Canada and it is a criminal offense, if you do the equivalency, we might need to apply for an actual criminal rehabilitation or a temporary resident permit. And the reason for his entry is going to need to be strong. So let's say employment reasons, or there's a wedding that he needs to go to and he's part of the wedding. So there's a whole lot more to it than just saying, oh yes, he is, or no, he is not. So hopefully that clarifies it, but you might want to do some reading on the temporary resident permit application as well as the criminal rehabilitation. Now, another client is asking, can I apply for a super visa if I received EI benefits? And so the answer to this is yes, you can. What super visa requires is that you provide your last year's notice of assessment, and what they look at is line 150 of your notice of assessment. And so long as your line 150 from your last year's notice of assessment is as per the LICO requirement, then you meet the eligibility requirement, the money requirement, the financial angle of it to apply for a super visa. As you know, there's other requirements that you have to ensure you meet. Obviously, you have to be a Canadian citizen or permanent resident. You have to get medical insurance for your family, whoever is coming, parent or grandparents. You need to do, they need to do an upfront medical exam, and you need to show that you are the biological son or daughter and or the legally adopted child. So those are the other requirements besides the notice of assessment that you have to ensure. So that, to answer your question, EI is okay. Just double check your notice of assessment. Somebody's asking about the requirements for an application that's not open yet, so I'm just gonna have to skip that. So if you're asking questions about requirements for matters that are not open due to being closed, I cannot discuss that. I don't know until the announcements get made. So right now, requirements for things like parental sponsorship, any other routes that are currently closed that I can't think of, if they're not open, it's only assumed that the last year's requirement or the last time they had it are valid. But keep that in mind that as soon as it opens up, usually there is one or two tweaks that were made. Usually it's not 100% identical to the previous application. So if you're looking at a matter such as a parental sponsorship or TR to PR applications, look at gathering your documents as per the previous requirements, but be prepared for any additional documents that they may require. But until it's not public on Citizenship Immigration website, I'm not really comfortable answering what I think may or may not happen. So since it's not open, that's where I'll leave it up for that. Another client is asking, I'm a retired US citizen. I live in Vermont. I own a property in Cornwall. I cross the border and stay there for 2 weeks and then return to US. I don't have any family ties to Canada. And how do I remain beyond the 6-month stay? So it's a very good question. We Canadians, we go to Florida a lot, and we call them as snowbirds. And we stay we stay there for 6 months or so, and then we exit. So similarly, if you're retired, you can definitely come to Canada. Make sure the officer knows that you're entering Canada as a visitor. You show as many ties as you can to the United States. Explain your travels to Canada, explain to them why you're coming, how long you're planning on staying, where you're planning on staying, and that you will do this frequently. But most individuals that are retired usually don't have issues with that because majority of the people who get denied is because the officers believe that you're seeking employment or you're probably looking for PR. An individual who's retired truly just wants to enjoy Canada, Canada culture, Canada weather, and so that's totally acceptable as a visitor. To extend it, you have two choices. You can either keep doing what you're doing, exit, re-enter, and then remain, and so long as you remain less than 6 months, you're okay. Applying for an extension is not recommended because as an American, you are visa exempt. Rarely does an officer give you a visitor visa record because the reply will be, well, you're an American, you just have to exit and re-enter, and the officer will do that reevaluation. So even though you could try it, most officers just send you a letter saying you're not eligible for this. So unfortunately, you're kind of stuck with the exit and enter and exit and enter, and at the mercy of the officer. The other thing you could do is either get a Nexus card. I mean, it's a lengthy process, and you go through an interview, but then it's good for 5 years. So then you can avoid that constant questioning back and forth with the officer. It again depends on how frequently you travel. So if it's a once a year thing or twice a year thing, then of course I don't necessarily think Nexus card is necessary. But if you're traveling like this gentleman who's staying 2 weeks at a time, or frequent traveler to Canada, a Nexus card may be something that you might want to consider. Plus, you can avoid the heavy lineups that we're having at the airport lately. So when you have a Nexus card, you kind of bypass most of that lineup, so there's a benefit there. But currently, I think the processing times are about 8 months just to get the interview. Once you get the interview, they will decide, and I'm sure the officer will most likely grant you the 5-year Nexus card, and then in 5 years, you renew it again. So those were, from all the questions we received, those, I kind of summarized it. I just looking and seeing if there's any other questions. Sorry, I'm just gonna have to put my face away. So a gentleman here is asking, how can I find someone from Canada to help me get to Canada? I'm not sure what that question is asking, if you're asking for an employer or if you're asking for someone to help with the immigration process. If you're asking for someone with the immigration process, well, hello, that's why you're here. You can contact the firm, you can book a proper consultation, we can evaluate what your needs are, and then tell you what your options are, and then assist based on that. As far as you're talking about sponsorship, that we don't help with. And I would caution you to not hire law firms or agencies that guarantee you with a massive amount that you pay to them for an employer. Majority of those are either not legit, or they are scrutinized heavily at the port of entry. And I get many clients that call me and say, I paid $40,000 and I got an employer, they got the LMIA approved, I have the LMIA, but then they rejected my work permit. Well, because it wasn't a genuine offer. And so immigration is very meticulous and very thorough. If it's not right, if it's not legal, and if you know that you're not supposed to do something, don't make the mistake of paying someone $30,000, $40,000 and the promise and the hope of Canada. Immigration will most likely find out. And on top of that, they can ban you from entering Canada. Do it the right way, and as our slogan says, there's always a way. But just do it the legal way, do it the right way, and save your $30,000, $40,000. An LMIA application does not, and nor should it cost $30,000, $40,000. At my firm, it ranges between $5,000 to $7,000, depending on the employer and depending on the size of the family, etc. But it definitely should not cost $30,000, $40,000. Maybe in 30, 40 years it'll cost that much, but definitely not now. So I caution you, don't pay friends or family or companies a large amount in the hopes that they're going to find you an employer, because on a daily basis I get emails and calls to say, I have a legit LMIA and here's a copy, but how come my work permit was refused? And it's because the officers are much smarter than you think. It's not the first application they've seen where it's made based on money. There's a thorough assessment, there's recruitment requirements, there's salary, wage requirements, they review your resume, why are you the chosen candidate, did you actually call those candidates that applied? I mean, it's endless. So do it the right way, and I'm sure if you do it the right way, there is a proper way for you to come to Canada. There's another individual that says, I'm an Afghan British citizen. What are the ways that I can stay in Canada? I have high education. This is a very good question. At the same time, why I'm saying it's a good question is because I get this a lot. And they say, okay, so they say their citizenship and they say that I have a high education and then say, okay, now tell me all my options. It's like me saying, okay, I want a car and I want a white car. And that's all I'm going to give you. And now you tell me what car is good for me. Well, that doesn't tell you anything. It doesn't tell you if I should get a Mercedes-Benz or if I should get a Honda Civic or if I should get a Toyota. By you just telling me you have a high education and that you are an Afghan citizen, it is probably 1% of what I need to know. There's far more options. What it tells me as an Afghan citizen, and also a British citizen, is as a British citizen, you're visa exempt, that you can come as a visitor. So I can tell you that obviously, and this is something you probably already know, all you got to do is an ETA. But if you're asking about options for permanent residency, with that information alone, it's impossible for anybody to tell you what your options are. So when you send an email, because some of you do send email to say, okay, this is my situation, even email is not good. Just do yourself a favor, pay the $75 consultation. It's Canadian dollars. Your British pound is far more stronger than our Canadian dollar. Book the consult, let me spend 30 minutes with you, and within 30 minutes I will tell you what your options are. And if the options aren't today, at least you have an answer. I can tell you it's not today because you don't have this. You need to do this to get to your goal. But I don't know what your options are because I don't have enough information. I would need to know your age, your education, your language experience. I would need to know if you have family, how much money do you have, do you have business experience, etc., etc. Once I have far more answers, and I guarantee you within 30 minutes I can get that out of you, I can tell you what your answers are. Now, sometimes, very, very few times, the options are kind of complicated to explain over a phone or a Zoom. I do what's called an immigration analysis. I send you a basic checklist. I say, send me these documents, and within 3 to 5 business days, I send you a formal written options. And then we have a productive conversation to go over those options, but whatever suits the need of the client. So start with the consultation, and then if I need more information, which again, I don't usually, but when it comes to business, opening up a business, I may require it, and then I'll let you know. Okay, I have, and I'm not obviously disclosing names, so I'm just saying who's writing what. Okay. Sorry, I'm just reading, and some of these questions are repeat, so I've already answered them. And so a lot of questions about provincial, not a lot of questions, but provincial nominee work permit. So what's the time? So once you get, the provincial nominee programs are quite lengthy. It's not like the express entry where you could in the past pre-COVID get everything finalized within 6 months. Even express entry is no longer express because it could take about a year to process. P&P pre-COVID would take about a year and a half. Now with COVID, it's quite delayed. How long you will have to wait for a work permit and et cetera, as I said in my first thing about processing times, they're unknown. And it depends on when you received it, but 4 to 6 months should be reasonable. But again, if you're still waiting or you're not sure, just contact, and I don't think you should do it through case specific. Each P&P has a direct email address. You can, and once you receive a file number, etc., you will get that. So just directly email them and say, this is my file, this is my file number, this is when I got my nomination, and I'm still waiting for my work permit, etc. And how much longer do I need to wait? Most provinces are quite quick to respond. If you go through the case specific inquiry, you might not even get a response. So just directly email the province, and that email address is how you get all your communication. So whatever communication you received when you received the nomination, just respond back to that same email, and an officer or an administrator, whoever, will reply to your specific questions. But again, caution you with the 4 to 6 months because it depends from province to province. BC has, because there's a lot of interest, the longest processing time versus Nova Scotia and Saskatchewan, for example. Okay, so I think that's it. I'm just gonna, yeah. And if there's anything more, of course, feel free to email us at info@thevisa.ca, and I'd be more than happy to answer it. Again, info@thevisa.ca, you can call us at 416-477-2545, and I'd be more than happy to address those questions. But asking a question can only get you so far because there's a lot of information needed. if you feel comfortable, just book a proper consultation and then we can go over it in far more detail. Thank you so much and have a good day. Until next time.